A very good afternoon to one and all. Well-acclaimed keynote speakers, directors, principals, HODs, and faculties from different colleges and various universities. I'm Steffi Mary Chandi, and it gives me immense pleasure to extend very warm welcome on behalf of Acropolis Institute of Pharmaceutical Education and Research, which has clubbed all of us for an international FDP on intellectual property rights and patents sponsored by IPTSE Academy. I once again welcome you all to second day of this international FDP. Sir Henry Ford once said, read books, listen to tapes, attend seminar. Their decades of wisdom reduced to invaluable hours. It is on occasion like this we get opportunity to enrich our knowledge and understanding. The main objective of this FDP is to provide an interactive forum for expressive exchange of information. On this note, let us move on to technical sessions of the day. It is rightly said that there is no shortage of remarkable ideas. What's missing is the will and way to execute them. To begin with our technical session, I feel elated to introduce our first keynote speaker of the day, Ms. Paulami Ghosh ma'am, IP and Commercialization at City University of London. Ms. Paulami Ghosh is a certified licensing professional with around 16 years of experience in intellectual property management and intellectual property commercialization. She has a master's degree in organic chemistry and bachelor's in law. She has worked in pharmaceutical sector for several years and at present works in academia, UK. Her works involve advising universities faculty on IP and startup matters, IP portfolio management at City University of London, technology scouting and assessment of the invention from IP and business perspective, IP commercialization at the university through license negotiation and startup. Ma'am, we are overwhelmed by your presence. I request you to kindly share your valuable.
Thanks, Steffi. Thanks for the kind words, and I'm grateful for this opportunity to come and share my experience with you all. So, as Steffi said, I work with academics like yourself in City University of London. And today our session would be about the significance of the intellectual property when we are talking about entrepreneurship and startups in the context of academia again. So I'll just share some of my knowledge over here. And as Steffi touched on Henry Ford, I think he's one of the greatest inventor and innovator and he has successfully commercialized his technology. So yeah, I'll start sharing my screen. Please do let me know if it's visible, because though we have technology, it's difficult where technology works and doesn't. So I have shared my screen. Is it visible, please?
Yes, ma'am, it is visible.
Great. So the first stage of technology is tick boxed. We are there. Before we start on the session, why we think that, why don't we know from you all, how many of you are have that zeal to have to start something new or have a startup or entrepreneur? So I would like the whole session to be a bit interactive. So if you can go to the chat box or type answers, because I can see the answers here, it would be great. So how many of you think that you have that zeal inside you to have to start something? And yeah, so if you can put your fingers together and on the keyboard. Yes, no? Well, might be towards the end of the session, we'll know a bit more. Okay. So why is it so important that we think about intellectual property when we are talking about the entrepreneurship and startups? IP is more involved in our everyday life than we actually pay attention to. There is every bit of IP. Like recently, there was a post from WIPO where we were talking about IP in a cup of tea. So there's quite a lot of intellectual property when we are actually having a cup of tea, from the start of brewing the tea leaves process to the packaging of the tea. So each aspects of that morning cup of tea has a lot of intellectual property. I guess you must have some knowledge about what intellectual property is. So these are intangible assets, which is equally important as you see a piece of a property that you might be staying in, a house as you call it. And there can be legal aspects or a fair dealing about how you are working with the intellectual property. So you can have the patents, copyright, trademarks, trade secrets, know-hows. These are the widest one known. And so when we start on a journey of entrepreneurship, entrepreneurship is again how we define it as a, or entrepreneurs are person who might be setting up a business and they want to take some gain something financial out of it. And we are looking into this. We are not looking into the business aspect. Sorry, if you can please mute yourselves. Sorry. Yeah, good. So entrepreneurship is how we are, a person can actually set up a business and take that into a consideration, taking into consideration the financial risk and how to take it forward. And it's okay.
All participants are requested to kindly mute yourself.
It's okay. Thank you. If we start with the invention, usually invention is somewhere where we think that what we have has been invented, something new has happened, and then comes innovation, where though we use inventions and innovation very synonymously, but innovation is somewhere where the invention has gone into a commercial stage and it has reached to the people that really can use it. Might be in this COVID scenario, we can very well give the example of the vaccines that has found its way into the public's hand. And most of these vaccines started their journey in the university's lab. And through nurturing and different process, it had come to work with commercial entities. For example, what we see in the Oxford AstraZeneca vaccines, where they have worked together and you have a final product. So this is also an example of the entrepreneurship. Might be it's someone's journey, where the professor's journey, where she started with that invention and finally the vaccines were into the hand. And this is to create that importance in that whole journey. Intellectual property in the form of patents, in this case, particularly for the vaccine, plays a major role. Branding is also a great way over there. And it's not now that this is becoming relevant and people are more interested. If we see towards a history, we, as Steffi was talking about Henry Ford, he revolutionized how we thought about automobiles. And it can be again Thomas Edison, who was an inventor and had like a lot of patents, out of which some he actually sold to some of the companies in order to raise fund to again invest in other inventions. So the whole entrepreneurship is a journey where you start with the invention, an idea, and you and of course behind that idea you can combine the intellectual property into it, and then you get to the stage where you the common public can utilize it. moving into it, we see different companies also. I'll try to give you an example, or try to give you exercise rather, if all of you can come together. And let's say all of you must be having a smartphone on your, in your hand. Maybe some of you are surfing on it. How about you tell me, like, how much of intellectual property do you find in that cell phone or the mobile phone? So if you can interact with me on the chat, it would be very nice. And we can take it together. A small part of the entrepreneurship journey, just to understand what is the IP around you. So I'm not sure whether chat is enabled here. Steffi, do you know whether the chat is enabled here? Like, for example, the mobile phones are, some part has patents.
Ma'am, chat is enabled. Participants can write down there.
Yeah, please, participants. What do you think? Like, I gave you example of intellectual property in a cup of tea, where you have, okay, yeah, it's coming out. Yes, copyright in what form? What else? What else do you find in a cell phone? What about softwares? Yeah, softwares are copyrightable. There is something here. What is it called? Apps, right? Yes, apps also have, you can, as a symbol. Yes, that's what I was going to. The logos, of course, if you know, the Apple brand value is some billions. Okay, we are going Android version. Yes, they have their technical know-hows. Great. Yes, there are the graphics that are important. The emojis that we use. Those all are IP rights, and might be the cell phone processes. Yes, processes would be protected by the patent. So I'm looking at the intellectual property aspects of it. Punchline for, yes, slogans, if you say. Yeah, there are lots of companies who use slogans along with their logos. Yes. So see, in our hand, we have a device which is actually having such a lot of intellectual property in it. So that's what I thought, that we will stimulate ourselves to think that how things which we have in our hands have such a lot of IP that we really at times don't look into it. So as some of you rightly said, that the patent protection is for the technology and the component in the patents. Software patents are not very, not every country is quite flexible about the software patenting. US is quite ahead in the game. UK is a bit conservative. And there are the technologies like the swipe technology, and that form of technology that can be protected. Then the copyright protection is towards the logo, slogan, graphics, trademarks. Of course, is a brand name you associate that originality and the value for the brand names over there. And then again, you have the design, how the patent, how the whole phone looks like nowadays. Samsung is bringing in a phone that can be folded. That can be a form of the design patent, or design rights, wherever it is, or where the camera would be displayed and what type of it is. So a lot of things goes. The first step of starting your journey is to think what IP you have in the invention that you are creating. So that's the analysis is required. And as you must have known from the when you had that intellectual property session, that it can be patents, it can be copyrights, trademark. Know-how is essential, especially for pharmacy backgrounds, or where the invention requires a lot of what is the step-by-step process. Like you invent a molecule, then it goes on to you do a lot of tests, what type of things it is ticking the box, and then you get a result or you do not get a result. This negative result is also your IP, because if somebody gets it, they won't have to repeat that experiment, and they can just and that can save them time, and that's what you are giving them, a competitive edge. So the importance, or the why I thought that I'll come up, we'll do this session, this interaction about the cell phone, was to just to have a glimpse of what the IP would be, what to think about it. So building on the slide before, so I call it the IP life cycle. So the intellectual property moves in cycles, to be very frank. So when we have an invention, we try to nurture the invention, and as I told in the first slide, that invention and innovation is a bit journey. So for innovation, you need to have that commercial application, and so when you invent something, so you need to have a thought. It doesn't have to be always that you need to have a finalized product, but I think as scientists, we all think about that problem solution. So we start our research somewhere to think that, okay, there is a problem and I think that I can solve it. And we take our small steps, might be in the journey. We take a step backward at time, or we change our course, but somewhere we have that in our target line that we need to find a solution for something. So that's the first step, is about invention, where we have conceptualized something and we are doing the test. And during this, the lab notebooks that you are keeping is also a basis of your intellectual property, because in patent at times, it's quite important to have those examples written down. And also that creates a lot of value if somebody can understand and put those logbooks together. It can be helpful for other, because that can give you some form of competitive edge later on. Then the second part is, once you have nurtured it, you know that this is okay, this is going good, this would be a nice invention that can help somebody. You think of putting some form of protection. It doesn't have to be patents always, but patents are the, as we call it in hard IP, patents, trademarks is a hard IP, which generates a lot of protection. So if you can file a patent, it's well and good. And even the patenting process also, you can take advantage of it, because you might file a provisional and take that 1 year period that is given to you, within which you can decide whether your invention is actually going to be an innovation and you can commercialize it. And after a year, you can take a call whether you should go for a PCT application, because you get a lot of time. Those stage gates are really helpful. Like you have that 1 year for the PCT filing, or after 31 months, you have the national phase. So you get time to think about it if it's patent, but it always doesn't have to be patent. For software, many a times you don't get, what do you say, that confidence that it would be granted, and the software patents can be quite costly. So there can be other ways, like you can think of trade secret. You can keep it hidden. We always give the example of KFC and Coca-Cola, where trade secrets are there. What do you say? They have always, that's their IP. That's the asset that they have in their company. And so that can be one process. Copyrights, whatever you are writing down, the moment you are writing it down in some tangible format, you gain that copyright protection. But all the IPs are very jurisdictional, or very, you have to seek protection in each and every country. So that's where you need some form of thought process going on, what you want to do. And then comes the commercialization, where actually you are trying to put that invention that you have, you have started and you have grown to some form of business format, or some form of way that it can reach the public, have that social and economic impact. And there you have to understand and discuss about the business need of it, the business model that you are going to follow, and if it's a licensing model or it's a startup that you want to start or a spin out. Usually when we talk about the academic scenario, we talk about spin outs where the company is formed within the university and it separates out from it, but has strong ties with the university since the technology is licensed from the university. So this is a whole cycle where it starts with that small idea in your mind and goes towards the commercialization and coming into the hands of the people that actually would utilize it. That's happened in the IP life cycle. Entrepreneurship, as I think, is a journey. It takes a lot of time. It's not like in research. Then it doesn't have to be separate. They can go parallelly, but it's a journey. It needs that patience built in, and also you need that business acumen that you should always seek help from. I know that there are advisors who are always ready to help, and also if you are thinking of making it into a business, it's better to talk with some commercial guys or commercial entities, because they know how to, as we usually say, the market fit. So you know where actually your product is delivering or is best used. So starting this early is always very helpful. As I was talking about, first step is define your IP. Once you have the invention, you have to understand what the IP need. So whether you need a patent, file a patent, or you want to develop it in a different way. I'll give you an example of one of our startups. Rather, it's a student startup. And this fellow, he worked in the eye care sector. He started making a shield for the blue lights that emits from the laptop or any devices. And he started in his dormitory in his uni time. And he grew the business. And I think a few days back, he was in the Dragon's Den. That is quite like a venture capitalist pitch. And when long back, like 3-4 years back, when he was starting, and asked him like, what is the intellectual property into it? He did not have a patent. What he said was like, he couldn't be bothered to have a patent at that time because money was scarce. What he did, he grew his brand. So his brand is called OcuShield, and today it's quite renowned and it has reached to the a lot of people. So that way also it can be, if you when you are doing a project, usually I do not I'm sure that all of you would be doing, you have acronyms for your projects. So if you can protect that acronym and use it in your papers before during the publication and all, that becomes quite a brand name at times. Then you can register the domain name and have a website where you are actually featuring the progress of the of your invention. But of course, before you do all those things, if you have an intellectual property division in your university, discuss with them, because if you give out things in the public, then might be you won't be able to file a patent. So all those things need to be there. So once you have invention, to think like what is your IP that is the most important. Then the next stage is IP due diligence, to understand who has the ownership of the intellectual property that you have developed. Usually it is determined by your IP policy and your employment contract. If the As I know for our university, all the IP that is generated out of employment belongs to the university. So you have to check who actually have the ownership of the IP. Also that due diligence is important. If you are using a piece of work from some other people, so you need that proper license or the permission from that person so that you can use it. So it's very important that you sort this out in the very beginning of the journey, where you are actually inventing and trying to figure out where what type of IP protection you need. Then it's like creating an IP strategy. So as I think I was already giving you the example, like this has to be about what you want to do. The IP strategy is whether you want to file a patent or whether you want to just stick with the brand name or you want to keep it a trade secret, and you want to put the know-how together, like the example of the lab books, notes, that is quite a part of the know-how. It creates a lot of value when you are licensing. So those strategies should come in your mind, or at least you should have the thought in your process, how you are going to do it. And also here you can seek some type of legal help to like a soundboarding, like while you are doing it right or wrong. So that, and also it's important, like might be at that stage you are not thinking about a business, but if you are thinking about a business, like if you already have a startup, in that scenario your IP strategy should be aligned with your business strategy. So if you are selling some type of cell culture, say, so your patenting should be in that area. It you may not need patents which are sorry, my knowledge of, though I did my chemistry, but my knowledge of pharmacy is different. I'm trying to give you an example, but might be molecules that are into the market. That type of thing might not be very important, but still, if you are developing something, it's good to patent it because it might not be directly utilized in your business, but you can license it to somebody else, like it happens for the term is not great, patent trolls who have patents but do not use them and try to license it to others. So this is where you are thinking about whole IP strategy. And then quite important is the IP valuation. Of course, you have created some IP, and I think all of us think like, oh, well, we have done this and it's very valuable. But to go out in the market and to understand actually what value it is. So there is a quote from Charles Dudley that there is no such thing as an absolute value in the world. You can only estimate what a thing is worth to you. And I have also understood in a hard way, there are lots of valuation techniques that we utilize, like the cost method, the income method, the market method. But at the end of the day, it matters like what somebody wants to pay for it. And that's why it's very important that you do what is called a market validation. As an academic, it might feel very daunting, but to be very frank, actually you do it already. When you go to a conference and talk about your paper, you actually talk, I mean, when you have somebody come up to you from the commercial entities and talk, okay, this is important for us. That's where you are actually doing a market validation, like whether what I'm inventing is actually good for somebody else. Or you filed or you have published a paper and you have a lot of citations. So those type of things are what you are somehow trying to gauge a value for it. So it's important that IP valuation, some form of IP valuation happens, but it's not absolutely important that it's very difficult to put a value to invention, since each one takes it in a different way. But of course, if you are really want to think about it, think about the funding that you have got to come to this stage, or think about if somebody gets your invention, how profitable it would be for them. Might be a pharmaceutical company who are working for a cancer research, and they are looking for a cancer drug, and you have something in your lab which is doing extremely well. So, and it's like a fruit of your 10 years or 15 years of work. If that company gets that molecule, it would actually save them this 10 or 15 years of work. So that's quite a lot of value for them. So that type of understanding, that type of part of the valuation is very important. I cannot stress more on the market validation part. Like when you go out, though it's not, at times my academics do tell me that business and research is different. Research, we mostly look into providing it as an open source to everybody. But what I say at times is like, if you, it's good that it's open source and people are taking it, might utilize, but it's mostly researchers who would utilize. But for that product to be, that research to be a product, you need that somewhere the help of some commercial entity. Or here is where the entrepreneurship in the academics that is important, or the startup environment that is quite important, so that you can take it and have that business skills around it and grow it into a product. So that's what is, I think is quite good. And yes, the IP commercialization, of course. In the academic, since I work in the academia, I'll talk from that perspective. In IP commercialization is, it's again the journey when you are trying to sell it into the market. But it doesn't have to be commercialization in the hardcore. It can be a knowledge transfer or a tech transfer. Commercialization mainly is classified very broadly into three categories. You can say the you can license your technology to a third party or an industry against some form of remuneration or some form of monetary benefits. You can have some collaboration with third party, might be, so that you work together and build towards, they have you have A, they have B, and you together can make a good product. So that can be there. You can have a startup or a spin out where you decide that, oh, my technology is a platform technology and I think I can do a lot about it, and I have the right team around me. I have a person who is rightly skilled for commercial activity. I have the technical guy who is good in developing this product, and I have a marketing guy. So these are all the three aspects of a successful startup. The team might be very important, the product, and the investors, the funding. So you can look at that aspects if you want to take that route. And and of course, I mentioned about licensing, the startup, and also you can sell your IP at times. So you assign it to somebody, and then they take it away. The difference between assignment and licensing is that in assignment, you actually give up the whole right to it. And for licensing, it is like giving a permission. I can give you the example of, say, you have a house. So you can sell it off. So the whole ownership of your house goes to somebody else. That is the assignment we are talking about in the intellectual property term. And you can rent that house to somebody who would be given the permission to stay in your house and would be paying you monthly rent. So that is the licensing, where you rent out or give a permission to use your IP against some monetary benefits. So these are everything that you need to actually think in the journey that lies ahead. And intellectual property, commercialization, or entrepreneurship or startup journey is not always easy. You need that persistence, you need that resilience. But at the same time, you need the correct team also to grow around it. So that's there. And so coming to the returns on the IP assets. So though these are intangible, that you cannot touch it, but they are worth enough or worthy enough to be in the balance sheet of company. And we see that in quite a lot of the big companies, which shows IP as a quite valuable asset. And we also see that companies have litigations around patents. We have seen the Apple and Samsung on the some on the features, I think. So those type of things, and we see it in everyday life, I think, more than we at times realize. And it's always good to keep on inventing and thinking that what value it can be there. So of course, the returns that we get for IP asset is in the form of royalties. Royalties are revenues that we are getting when we are licensing it, and you can have a lot of modules that can be available how to calculate your royalty. This is when the university is this is when the university is actually licensing the technology. Yes. So this is when the university is actually licensing the technology that you can expect a royalty return. And in case the academics start thinks of starting a startup, then they might be having to pay a royalty for licensing the technology from the university. So it has to be either where you are placed. Either it can be a licensing in or licensing out, and royalties are calculated in different ways. There are rules how you can do it, but it's again looking around and what the licensee wants to pay for it. It's again a negotiation strategy that you have to build in. And though this are just like one liners, but lots goes into it. Whole IP commercialization can take years. We have an example which is like it took us 10 years for successful commercialization, and it is in the civil engineering area, where people are very conservative about changing the way they do things. But you never know. So it's always good to keep going and keep your patents alive. If you have a patent, or if you have a know-how to, or a trade secret to keep it safe. Then returns on the IP asset can be in the form of sale. You can, I think I touched upon this when I was discussing about the IP commercialization. So if you sell, you can have a lump sum amount that can be agreed to be compensated. If you are in a startup, then the exit, of course, they look into a lot of those intellectual property aspects. And believe me, when the investors look into all those files, they are quite rigorous. So it's always good to have your IP strategy handy, your what you want to do with the IP quite well defined. And defensive tools, you can use patents as a defensive tool. Might be you are not using it yourself, but as you know that all intellectual properties are, as they are called, as negative rights. So might be it doesn't give you the power to practice your invention, but at the same time it somehow stops somebody else to use what is yours. So you can use it as a defensive tool, and you can make people to license it. I think these scenarios are coming up in during the standard essential patents, where there are patent pools, where the 4G, 5G companies are putting their patents all together, because they have realized that taking individual licenses, it's not possible. So those type of things also comes up. So that's what we are looking for, returns on the aspects. This would be a bit more on the summarization parts, but I think again, I cannot stress on how we need to start thinking about intellectual property and look around for what IP is, what IP that you are developing, whether it's patentable. So of course, what the things that we need to remember is defining the IP. So yeah, we know now that we need to look at the thing and think what IP is there. Using different form of IP. From my experience, I have seen combining patents and know-how can be very fruitful at times. And also I tend to, split my royalty rates accordingly, a bit going for the patents and half a bit for the know-how, because know-how is something like the secret sauce, like at a particular temperature. If you stir the product or the solution, then the crystallization might happen fast. So those type of small things that might be, it's not important for to cover in the patent. Might this is very vague examples though, but still just to give you a sense of what can be there. And again, you can develop your trademark as a, or the brand as a very important aspect. So next time when you are naming your project, might be give a bit more thought on that. Might be that can be something that you can take forward for your product, for your product. And Then again, aligning the IP strategy with the business strategy. I cannot stress more on this, because if your IP strategy and business strategy is not aligned, then the fruit that you are wanting to get out of your business, it's difficult to achieve. IP gives you that monetary, or is it the monopoly at times. It gives you the added advantage or added value. So you need to align it with the business strategy, and might be file patents in the area that you think would be helpful for you to defend your competitors, or have an edge over your competitors, or keep things secret. Don't publish anything, so that until your product is ready, nobody can actually overcome you. IP strategy, at times people think that IP is costly. So when I'm building, I have heard a lot of startups say that we are not actually thinking about IP because it's very costly. We have money that we need to develop the product. We cannot invest in IP. So it doesn't have to be a costly thing. You can think about copyright, might be. So you can think about know-how, trade secrets. So those can be important. Seek legal advice whenever you are in doubt. So there are or some business, there are people who are there. I think LinkedIn can be used quite nicely, because there are people who are there who can help you out, who would advise you. So always nice to talk to people, but at the same time, you should know where and how much to talk. It's not good to give out whatever you have. And also in this context, I would say, whenever you have an invention and you are talking to a third party and you think that you need to protect yourself, first is, of course, use that caution not to tell everything. Second is that use a NDA, which is called non-disclosure agreement, with them. I'm sure your legal department in the university would be able to help you out, or in the internet you have non-disclosure agreement. But do see if you can be a signature. If it's your startup, yeah, if you're a director, you have the signatory authority. But in case it's a university, it is usually someone in the university higher up who signs the non-disclosure agreements. It's a contract, more or less. And for a university or a company, it's very important to have some type of IP policy or IP clauses in the employment, to be very clear, like who owns the IP and what is supposed to be done with the IP. I have seen in university sectors, to encourage entrepreneurship, usually there are some form of incentives in the form of revenue sharing. If there is a revenue that comes out of commercialization, then that is shared among the academics. So that type of policy or IP clause is very important, be it a separate company. And also understanding the value of IP in the company, or whatever IP invention you have developed. So do regular IP audits, like what is there, what can be protected, what doesn't need to be protected. Keep your logbooks very handy and keep it nicely. So those are the points I think is very important in the context of seeing where the intellectual property is. And I think that's what I have to share with you. And I'd love to see if you have any questions. Yeah, that's me. And I'm happy to, if anyone wants to reach out to me. So I've provided my Gmail contact and LinkedIn. I'm on LinkedIn too. Thank you so much for listening to me.
Thank you, ma'am. I'm sure the information you shared would surely be beneficial to all our participants. Now, we move ahead to question and answer session. I request all the participants to put your questions in chat box, if any.
So since there is no question, why don't I ask you a question? So what about
Hello.
yeah, while I see this question from Saurabh, I just give the another question to all the audience, I think. So now that I shared my experience about the significance of IP in entrepreneurship. So if you are an entrepreneur, what do you think? What are the steps that you are going to take so that tomorrow there can be some successful commercialization? Okay, so I can, yeah, if you can type your answers, I'll be very nice, and I'll take the questions what's here. What are the major difference in Indian patents and world patents? Okay, so sorry for that. I have to have a very good comparison of the Patent Act and all those of the rest of the world, and that's I'm not a patent attorney, so I cannot rightly answer you. But the patents are very territorial rights. So if you are granted a patent in India, you have the rights to only use it in India. So you cannot go to the rest of the world. So for that, you need to a strategy of going in other countries. Does IP protection have a time limit? Yes, IP protection does have time limits, and it differs from patents. So patents have usually 20 years from the date of filing. Copyrights have 70 years from the date of the author's death. So that's quite extensive. And for trademark, it's also like again, it depends from country to country. It's like 10 years. There are design rights where it can be 5 to 15 years. So you need to check, and when you are developing an IP strategy, that's when you actually try to see what is the best way out. And trade secrets, it's so long you can keep it a secret. Coca-Cola still has its trade secrets.
Thank you, ma'am. I would now request co-convener Ms. Akansha Dwivedi, ma'am, Assistant Professor IPER, to provide Certificate of Appreciation to Ms. Paulami Ghosh, ma'am.
Thank you, Steffi, ma'am. Ma'am, first of all, I would like to say that was very informative session. Ma'am, please, can you stop just sharing your screen?
Oh, yes, I always forget this.
Yeah, please.
I should have remembered it.
Yeah, please.
I can see myself, so I was like, okay, this is okay.
Yeah, please, ma'am. Ma'am, it was very, very nice session. And as a token of thanks, please receive this certificate of appreciation from our side, ma'am, from on the behalf of IPER and on behalf of IPTSE Academy.
Thank you so much. That's quite a yeah. Thank you. I'm humbled.
Okay, thank you, ma'am. Thank you so much.
Thank you. Have a lovely day.
Okay, same here, ma'am.
Yeah. Bye-bye.
Bye, ma'am.
I can leave, right? Okay.
Thank you, ma'am. So coming to the end of this session, I would like to request co-convener Ms. Rakhi Khabia, ma'am, Assistant Professor IPER, to propose vote of thanks.
Thank you, Steffi, ma'am. I consider it a great privilege to propose a vote of thanks. I, Rakhi Khabia, on behalf of Acropolis Institute of Pharmaceutical Education and Research and entire supporting team, extend a hearty vote of thanks to our eminent speaker, Ms. Polani Ghosh, IP and Commercialization Consultant at City University of London, United Kingdom, for gracing us with her thought-provoking address regarding the importance of intellectual property in entrepreneurship and startups. Ma'am, you have explained so beautifully how research being going on in the academic institutions can be protected via patents and via IP strategy, and how one can become an entrepreneur. I hope after this session, many of us will think of becoming an entrepreneur and will promote the culture of startups among our students also. Ma'am, we all are inspired by your great words. The session was interactive and you have explained the things in very simple way by quoting examples of the things that we use in our day-to-day life. Thank you so much, ma'am. I would like to thank Institute Management, our visionary principal, sir, Dr. G.N. Dharvikar, for his immense support and guidance. I think the team of IPTSE Academy, Saurabh Sachdeva, sir, Dr. Sheetal Chopra, ma'am, Vansh and Ria for arranging all the eminent speakers. And finally, thank to all our respected faculty participants for their presence. Thank you, one and all.
Thanks. My pleasure to be here. Thank you so much. Thank you, everybody. Have a lovely day. So and thanks for all the appreciation and the token. Thank you so much. Bye bye. Have a lovely day.
Thank you, ma'am. Now, we move ahead to second technical session of the day. I am honored to introduce our next keynote speaker, Mr. Vaibhav Dalvi, sir, Head, Intellectual Property, Wellspun Group. Sir has 14 years of rich experience in IP, from conceptualization, prosecution of IP, including strategizing complex patent litigation. Vaibhav sir holds a degree in BLS, LLB from prestigious Government Law College. He holds Masters in Business Law from National Law School, India, Bengaluru. He holds BSc Major in Physics from Elphinstone Law College. He also holds Diploma in Patents and Cyber Laws. He has set IP department for Wellspun Group. Vaibhav sir deals in IP litigation over the globe, mainly in USA and Europe. He has expertise in critical and strategic thinking, legal interpretation, and solving complex legal issues. He has keen interest in commercialization and negotiations of IP. With his rich experience, Wellspun has filed maximum number of patent applications in the field of home textile in India and USA. Vaibhav sir is also registered patent, trademark, and GI agent. On this note, I am honored to invite Mr. Vaibhav Dalvi sir to share his knowledge with us.
Thank you very much. Am I audible?
Yes, sir, you're audible.
Perfect. Let me just share my screen. I would assume that my screen is visible. So there are different various kinds of intellectual property, and it's actually very unfair to speak about each of them in a span of only 1 hour. So what I'm planning to do is this: I'll focus on main intellectual properties which deal with pharmaceutical sector in a little bit of more focus. And other intellectual property, I'll be very brief about. So let us. Yeah. So what is an intellectual property? So it is an intellectual activity which may lead to creativity or invention, and it is in the form of intangible asset. Now, TRIPS, the trade-related intellectual property agreement, is majorly governs and try to make the IP laws uniform throughout the nations, throughout the globe. But the IP law will always be the law of the land. So it will be a country-specific laws. So each and every nation will have to, those who are member nation of WTO will have to adhere to minimum standards, what is being given under the TRIPS, and then they may go a step further and have their own set of IP laws. So why do we need to have intellectual property system in general? Interestingly, the patent was first came in the world somewhere in 1800, where the patent was granted to a culinary dish, like the food items, and the monopoly was granted for the period of 1 year. Now you can understand if someone has, like people must have been watching Master Chef, and if they come up with the unique dish, the monopoly is given for the period of 1 year. So what it gives you a sense of recognition that you have come up with something new. Then also it gives the financial benefit. When there's a monopoly, then you're the only person who will be able to exploit that invention. I
May I
think.
please request all the participants to mute themselves?
Thank you. So it also gives the financial benefits. And then when I'm sharing my patent with someone, there's a knowledge sharing against which I'm getting a monopoly rights for the period of 20 years. And if I don't share my invention with the world, what will happen? Then my invention will go with me when I leave the world. And as against to which, if it is shared via a medium of patent, so there's a development of technology. So in a nutshell, you'll be able to understand, like, this is how IP system is built upon. Now let us understand about what are the various types of IP: patent, trademark, copyright, design, plant variety. These earlier IPs I will be speaking in more detail. Plant variety, as the name suggests, plant is like it's a variety of the plant and is registered under the Indian Plant Variety Protection Act. So it can also give a new plant variety existence, but a different variety of the plant that can also be protected under this particular IP. Geographical indication. And now this GI is only applicable to the goods. It could be for the agriculture good, or it could be a natural source of good. So far India is concerned, we have also added a manufactured goods. So when we look at Europe, so there is a wine which is famous in Europe, again the Scotch whiskey, which is manufactured purely in Scotland. When it comes to India, we have a basmati, which is now Pakistan is also claiming right over it. So the law of the land, what it says, is about the goods, whether it is agriculturally produced or there is available in natural resource. India has gone step forward. It also talks about the manufactured goods. For example, Banarsi sari. So that's something which is manufactured by indigenous people of India that have received the geographical indication. Another example is Kolhapuri chappal. Now, one interesting fact I would like to share about GI is this Rasgulla. Now, West Bengal has a GI tag for Rasgulla, which is sweet and white in color. Odia also has a GI tag for their little darker color, like a cream color Rasgulla, which is not very sweet in taste. So there are two different GIs were also awarded for the same piece of article, but were distinct enough. Next IP is semiconductor integrated circuit layout design. This is very, you must have seen the motherboards and the chips in it. Semiconductor integrated circuit is sort of like integral part of those chips. Manufacturing this semiconductor IC or like coming out with the layout design of these ICs is very tedious job, but when it's come in the existence, it's very easy to copy it. So whoever has come up with this IC, if it is not being protected, then all the efforts like time, money, and everything which is put into manufacture this IC will go in drain. Second thing is last one is a trade secret. Now, as such, like USA, there is no uniform or there is no codified law to deal with the trade secret. in India, if there's any NDA or CDA, like non-disclosure agreement or confidentiality agreement is signed, then it will be governed under the Contract Act. In absence of these agreements, if the trade secret is stolen or it has been used in a not a diligent manner, then relevant section of IPC will come in the picture. There's another IP traditional knowledge, but as such, it is not recognized as an IP. But in India, we are maintaining a digital library of which. The reason of maintaining library, it all started when the patent was filed in USA for turmeric, and then we opposed that patent and we said it's a traditional knowledge of India. So this is when in 2000 the digital library came in the place. So now let us understand what are the IP components on a pharmaceutical product. Now, assuming I come across a novel drug, or like one of you invent a novel drug, molecule or compound, or existing drug, molecule or compound with a novel process, or which is a less complicated process, then how it will be protected? First, it can have a protection under the Patents Act. Also, it can be protected under trade secret by not disclosing it. For example, one of the example of trade secret I would like to mention, like all of you must be knowing, the Coca-Cola recipe. This burgers also, like McDonald's sauce is also one of the trade secret recipe. And this is also, you can consider patenting, protecting your invention. Most of the pharmaceutical company, they try to protect their invention by way of patent. Reason being, if the product is launched, there's a possibility it can be reverse engineered and the same sort of like a same drug can be manufactured. So the patenting is considered as one of the most reliable source. In 2005, there was an amendment under the Patents Act, and under which the product patent was also granted, and hence the patent has been it's been encouraged throughout the India. Now, when the product is launched, then there's a branding or logo comes in the picture, and so how it is protected? It is protected under the trademarks. It can also have protection under the Copyright Act. So when you have a trademark, you can also exclude other people from using the similar, deceptively similar or identical brand like your own product. When you launch the product, when there's a branding, so it will package under a box. That packaging can also be protected under the Copyright Act. And then there's one more point, which is very interesting, is that a unique shape of pharma product, it's a unique tablet, can also find its protection under the Designs Act. Moving on. So what are the pharmaceutical patents which has been like seen in recent time? Is a drug compound patent. This is about it's one of the strongest form of patent when it's a product patent. And most of the companies, they try to secure their patent applications with this form of like a combination. The claims which are used under this type of patents are Markos claim, and it will talk about the efficacy in these patents. Second is a formulation or compositions of patent, and under these formulations, they will come up with the formulations of a certain formula or process, and then it will try to protect that particular formulation. Synergistic combination patents, which basically means there's like two different drugs and they're combined together and come up with a different synergistic effect. As long as it is not covered under the Section 3 of the Indian Patents Act, then it will also get a grant under this synergistic combination patent. Technology patent is something a part of patent. For example, the test masking. If that issue is... I think Mr. Deepak wants to add something.
अर्जेंटीना देश का नाम है, जैसे भारत है, पाकिस्तान है।
I request participants to kindly mute yourself.
Thank you, Mr. Deepak. Technology patents, I was mentioning about it. For example, if any particular like a tablet is having certain issues of taste, so taste masking, that issue can be addressed with the technology types of patents. Volume of patent is also another form of patent when there's a different physical form of the similar drug or compound is been tried to protect it. It will find its protection under the volume of types of patents. Now, what are the basic patent requirements? The what is basically, let's understand what is a patent. Patent is a right granted under the Indian Patents Act. So the patent, the basic key requirement is an invention. What section 21G says is like it's about either a new product or a new process of manufacturing existing product with the help of inventive step or industrial applicability. So when it comes to new product or new process, it will speak about the novelty. Inventive step, that one of the important criteria, it should not be obvious. And industrial applicability means it should be used in some sort of like industry. So what are the basic about the novelty? There are three types of novelty. Absolute novelty, which means it has never been used anywhere in the world or it was not published in any part of the world. Now, why publish any part of the world? Patent also gives protection to the idea. You do not need to show a prototype necessarily unless and otherwise examiner is asking for it. So even you can protect your idea by way of an patent. So absolute novelty, it is not used anywhere or not published in any part of the world. Relative novelty, so you can understand that it may have been used or may have been published in somewhere, but you have worked on that, and a person with the ordinary skill in the art may not have come with the result what you have come out. I'll repeat. There is been the particular product may have been used or may have been published somewhere, but you have worked on it to come up with a different product or a similar product with a different process. So that's called relative novelty, and that's where your non-obviousness steps come in the picture, and the term that a person skilled in the art will come in the picture. Now, it will not talk about the layman. It will speak about the skill in the art. That means someone having a decent knowledge in that particular industry. Lack of novelty, which is coming under the term anticipation, under which deals basically about the prior publication, public knowledge, public use. Public use has also been used is because most of the people, for example, traditional knowledge, the turmeric case, what we saw. So that will fall under the term lack of novelty. What could be the exception of this rule of novelty? Now, if I have certain particular patent or certain particular invention, I have disclosed or I have discussed this particular invention to my colleague or to my friend or a relative, and that my friend, colleague, or my relative discuss this my invention without my consent publicly or publish that particular invention. So, in absence of my explicit consent, this publication will not be held valid. Now, assuming you are all like learned people and you may present your research papers, and assuming you don't protect your research, then you will be given a 12 months grace period from the date of your research being publicly made available. Within 12 months, you can file for patent application. Is certain things, like the next point is certain things, if you have communicated with the government of India itself, or if your work requires a reasonable public trials, then in that case, these are the exceptions to the rule of novelty. And it will also evade the public use examples with this. Next is the inventive step. Inventive steps under the Act means a feature of an invention that involves technical requirement as compared to the existing knowledge or having economic significance or both, that makes the invention not obvious to a person's skill in the art. So as I discussed earlier, it should be a non-obviousness. It should be not obvious to the person's skill in the art. There should be a technical advancement and the economic significance. Last point for the protection is the industrial application. Now, India is the country who has come up with this requirement, industrial application. Major country, for example, developed countries like USA or Europe, they usually focus on novelty and inventive step / non-obviousness. But in India, we also speaks about the industrial application. The Act, how it defines as a capable of industrial application in relation to an invention, which means it can be made, can be used in at least one field of activity, or can be reproduced with the same characteristics as may necessary. Now, the patent examiners, they used to interpret industrial application. The invention could be manufactured in a tangible manner. But now this approach has been moved and they are being very liberal in terms of the industrial applicability. Now, let us understand what are not inventions and what is not patentable. Apart from this section 3, which speaks about what are not inventions, and section 4 speaks about the invention related to atomic energy. So apart from section 3 and 4, rest all of the things are considered as an invention, will fall under the Indian Patents Act and can be protected as long as you meet this criteria of novelty, inventive step, and industrial applicability. Now let us understand what are not inventions. If it is a frivolous or contrary to well-established natural laws, if it is against a public order or morality, a mere discovery, for example, apple falling down, there's a gravity. So it's a mere discovery of scientific principle or the formulation of an abstract theory. Discovery of any living or non-living substance occurring in nature will also be not considered as an invention. Section 3D, mere discovery of a new form of a known substance which does not result in any enhancement of a known efficacy of that substance, or mere discovery of a new property or a new use of a known substance, or mere use of known process, machine, or apparatus, unless such known process results in a new product or employs at least new reactant. Mere admixture, as I mentioned, I was giving the example of earlier patent. So mere admixture of two existing drugs resulting into the mere enhancement of the efficacy, then it will not be considered as an invention under this section 3E. Mere arrangement and rearrangement. For example, we all know the car has 4 legs, but if I change the way the wheels have been arranged in a car, so I just rearranged it, so that will not be considered as an invention under section 3F. Section 3G was omitted. The method of agriculture or horticulture. So agriculture methods, the way you plant, this has been excluded and not considered as an invention. The medical treatment. So that treatment is not only restricted to the humans, but as well as other living things. Plants and animals, they are like any new form. If there's any hybrid plants or hybrid animals, they are considered as they are not inventions under the Indian Patent Act. But which is not the case, I would like to mention here, in USA. In USA, you can patent anything under the sun. And Mr. Bose, the person from Indian origin, he had come up with a certain microorganisms which could eat oil. So they were spread on the, like when there's an oil spill in the sea. So with this sort of microorganisms, they were able to deal with the issue of oil spill at the sea. Next is a mathematical or business method or a computer program per se or algorithms. Now, these are something, it's a very interesting, and a lot of examiners are having issues with the computer program per se. But with the advancement of e-commerce, you will also understand the business method. When e-commerce try to protect itself, it is very interesting to know that Amazon has a one-click purchase patent. So that will give you the very, like you can able to purchase very quickly. And Amazon has also secured that patent. Not only secured that patent, they had also initiated litigation, and they were able to recover the damages in USA. So since advancement of e-commerce and computer program per se, ultimately e-commerce is
जो कह सकते हैं कि जो हमारा इंट्रोडक्शन पार्ट था वो हमने कंप्लीट कर लिया था. टुडे लेट मी शेयर द लिंक, लेट मी शेयर द स्क्रीन. हम पढ़ने वाले हैं अबाउट द इंडिविजुअल प्रोडक्ट्स. हम सारे प्रोडक्ट्स को इंडिविजुअली डिस्कस करने वाले हैं. ये अपन ने ऑलरेडी पार्ट देख लिया था कि एंटीहिस्टामिनिक्स क्या होते हैं. तो जो वो ड्रग्स जो कि हिस्टामिन के रिलीज को या तो इनहिबिट करते हैं या तो उन्हें एलिमिनेट कर देते हैं, ठीक है, जो कि एलर्जिक रिएक्शन में. हिस्टामिन मतलब एक ऐसा मॉलिक्यूल होता है, एक ऐसा कह सकते हो ट्रांसमीटर होता है, एक ऐसा मीडिएटर होता है विच इज रिलीज्ड ड्यूरिंग द एलर्जिक रिएक्शंस. ये अपन ने कल देखा था, ठीक है. उसके बाद में हाँ, हिस्टामिन वाज फर्स्ट आइडेंटिफाइड इन 1910.
Thank you, Anamika ma'am. I would have loved to understand your details about the molecule, but I think we are here for the different subject. So jokes apart, computer program per se, I was mentioning about that. Software, like software has its protection under the copyright, but under the Indian Patents Act, people are more concentrated of getting the patents. And again, this is something, a trend which is also very popular in USA. Excuse me. In USA, when you file patent application for your computer program, you can also able to like list your source code along with your patent application. So these are the areas where the Indian like IP system is catching up. Next is a literary, dramatic, musical, artistic work, creation of like cinematographic work or television productions. They are something which is they find their protection under the Copyright Act. The scheme of rule, method of performing mental acts, method of playing games like playing rummy, they are also not considered as an inventions under the Section 3. Presentation of information, like I'm sharing this PPT, giving this information. The way of presenting an information is also not an invention. Topography of integrated circuit, we saw that like in the previous slide, it has its own sort of protection. And then lastly, traditional knowledge. As such, it does not have, like it's one of the actually considered as a ground of refusal of the patent. It also finds its place in Section 25 in pre-grant and post-grant opposition. So these are basically, you will understand the list of items which are considered not as an invention. And I mentioned about the Section 4, which is an invention related to atomic energy. Now let us understand what rights I get if I'm a patent holder. So it's an exclusive right to prevent a third party without a patent is consent to make, use, offer for sale, or import a patented product or a product with a patented process. So these are the exceptions. So these are the, it's a sort of a negative right in which I'll be able to enjoy, but I will be able to be more beneficial. I'll be able to make money out of it when I'm able to prevent the third party. How will I be able to make money out of it? Is either I assign my patent or license my patent. So if I'm a patent holder, I'll also get the right to assign or license my patent. not only that, right, like I also have right to surrender my patent. Why would I want to surrender my patent? If I want to be a philanthropy, or I want everybody to exploit this patent or the invention, then I have a right to surrender my patent. uh, then why all this effort of patenting it? If I don't patent it, there's a possibility someone else may come and patent it and may also exclude me along with the entire world. And if I want everybody to use it, so maybe I can have the right protected and have it surrender. This is something like it's a very long shot. Like some people can simply like prepare the research paper, make it publish, make it as a like public knowledge, and in anticipate it will come under the anticipation if someone else is trying to file the patent application. So this is something compulsory licensing. Now we are in the world of COVID, we are in the pandemic, and we are having this virtual, interaction. The compulsory licensing now. Why people are talking about compulsory licensing? You must have come across in the like sometimes it was trending in the newspaper that India is fighting in the World Trade Organization and asking like and putting its stand that this year, this pandemic is a good ground for a grant of compulsory licensing. Now, compulsory licensing is nothing new. It has been there in Paris Convention also. When TRIPS was introduced, they did not call it as a compulsory licensing, but they mentioned it as a like use of a intellectual property without the owner of like used by someone who is not the owner of the IP. This is how they had captured in the TRIPS agreement. The section 84 speaks about the compulsory licensing of the patent application. These are the requirements that under which a compulsory licensing can be applied and granted in India. So first is the reasonable requirement of the public with respect to patented invention has not been satisfied. Patented invention is not available to the public at large at a reasonably affordable price, because I can say it is available, but if it is not affordable, then it is not met. Then the last point is patented invention is not worked in Indian territory. That assuming if it is not work, but is imports allowed as an exception to the non-working theory. So the court held that as long as the patent is being imported to India, the patented invention is being imported to India, it can still qualify as it has been worked within the territory of India. One of the key requirement under section 84 is this: the 3 years should have been expired from the date of grant of a patent. So if it is not expired within 3 years, then a third person cannot ask for compulsory licensing of a patent. But this is not the case when it comes to the government. Government can ask in case of emergencies, public health emergency, the government can ask for a compulsory licensing of a patent. This is requirement is not only in India, but you can find its application in Europe, also in USA and like Australia, like most of the countries, they have it. Now, people think that India is granting compulsory license. India is not the only country. Rather, India has only one compulsory license granted so far. Recently, sometime back, Germany applied for compulsory licensing of patent for the HIV-related drugs. South Africa has been country, they are battling with the HIV issues for really long time, and they have been like constantly asking for a compulsory licensing of the patent, and which has been granted. So I thought I'll just also touch upon the compulsory licensing of the application because most of you are from the pharmaceutical background. Now, another point I wanted to discuss is about the evergreening of patents, which is something found its place mostly in pharmaceutical sector. Now, you will see a patent was applied in 1980 for active ingredient lamotrigine. After the lapse of 12 years, the patent was valid for the period of 20 years, which will expire in 2000. But in 1992, a patent application was made for chewable pharmaceutical composition for lamotrigine. and then the patent was extended for further period of 12 years, and it got expired in 2012. So for a similar compound or active ingredient, the patent protection was for the period of 32 years. So this is evergreening of patents. You can work around, you try to, you may able to extend the period of your patents. Now, most of the pharmaceutical companies, they face major issues is that most of the countries have first to file, not first to invent. American Invents Act recently underwent amendment, and they have also come up. They have also identified and acknowledged first to file patent application. So any pharmaceutical company develops with a like some new drug. By the time they get FDA approval, there could be like 5 to 15 years may have elapsed. And when they have to first file patent application, and then they're left with only 10 to 5 years to exploit their patent, or their like all the research what they have, like money what they have put in into. And this is when the evergreening of patents comes in the picture. I don't support this, but this is something everybody's talking about, that compulsory, that there should not be any patent on the vaccine. But when we are facing the pandemic, the share prices of these pharmaceutical companies were going high. It's not only the person who, like the pharmaceutical companies are expecting to make the vaccine and make money out of it, but even the normal consumer or shareholders wanted to put in money and expect some good returns out of it. So it's a vicious circle, and where like there has to be certain win-win situations so far patents are concerned. Now, this is something you will see. Nutshell is a workflow chart for the filing of patent application. Now, as I mentioned, is a first to file. So it can be protected your idea. So if I have an idea, then I'll file a provisional application, and I'll try to put all the masala together, and I'll put everything. So I'll try to club everything. Is there any way we can mute the participant?
Meenal Chaudhary ma'am, kindly mute yourself. Meenal Chaudhary ma'am.
Please mute yourself.
I'm audible. I can continue. Thank you, Meenal ma'am. So the provisional application, I was talking about it. In India, you don't have to file with any of the claims. Europe, if you don't file with any claims, then it makes it a little complicated when it comes to the complete specification. In USA, people also prefer filing with the claims. But coming back to I want to have a priority, I file a provisional application, then within 1 year's time, I file my complete specification. I have an option of requesting for the early publication. And if I exercise that option, that my patent will get, application will get published. Or anyways, within 18 months from the date of my first priority application, it will get published. Within 48 months, I'll have to make a request for examination. And this is a mandatory requirement, failing which your application will be deemed to have been abandoned. So it's as well as falling in a public domain if it is published. There's also, under the new provision, there's something called expedited or express examination request, under which you, it's kind of like you pay 4 times of the fees of the like Form 18 fee, and then you will be given a priority treatment, and your application will be examined on a priority. Once your application is examined, then examination report will be issued to you. Within 6 months period of time, you have to give a response to which, and you can request for extension up to period of 3 months. So every month you'll have to seek for extension to respond to the examination report. But this is not something, it's a matter of right. This is on the discretion of the patent examiner. So it is always advisable to respond to the examination report within the period of 6 months. Then after the examination report, you examiner may accept your response or may reject it, and then he may give an opportunity to be heard. And in the during the hearing, you'll be able to make your case and able to identify that how your invention has a novelty, inventive step, and how it has a industrial applicability. Now it also opened doors for a third party when the patent application is getting published to file opposition. So before it has been granted, a person can file pre-grant opposition, or can file, or after it is granted, you can file a post-grant opposition. In USA, there is no concept called pre-grant opposition. Even in Europe, there is no concept of pre-grant opposition. It's mostly found in India. There's a pre-grant opposition. In USA and Europe, you will only find a post-grant opposition. So once a notice of allowance is mailed, either in USA or in Europe, then so like for example, in Europe, you get 9 months to file opposition against that patent if it is in the European Union. Assuming you miss the window of 9 months, then in whichever countries that patent has been validated, you can file you have to go in that individual country and file for rectification of the patent. So now let's move on to the trademarks, the next IP, and which is something like most relevant IP for pharmaceutical also. So what is the trademark? Anything which is capable of being represented graphically and capable of distinguishing the goods or services of the other person. Now, for example, if I start with a Tata Bye-Bye Motors, then start manufacturing goods, then I may not get a trademark because it may not distinguish the goods and services of the Tata Motors. Now let us see what are the conventional trademarks. So the trademarks, like for example, which has been applied to the goods. So these are the trademarks. Then what are the applied to the services are called service marks. For example, I am providing a software development service or a software management service, IP management service. So that will come under the service mark. Label mark, logo mark. For example, the Coca-Cola logo. So that will come under this, or Nike swoosh. That will find its protection under the conventional trademark. Certification mark, collective mark. Certification mark, for example, ISI. This will have its protection under the certification mark. Collective mark. If I tomorrow, like Indian Merchant Chambers, it's an union, so they can file their trademark application under the collective mark. Now, these have been the conventional trademarks so far. And now, with the advancement of time, the non-conventional trademark have also come in the picture. There are 3D marks which are becoming very famous. Sound mark, the lion's roar for MGM Grand is very famous, and that has been protected under the Trademarks Act. The Apple tune, the caller tune, is also been protected under the sound mark. The smell mark, if you know about the tennis ball, the particular smell which the tennis ball has, that has been protected under the smell mark, under the trademark. So now, how the trademark may be refused? Again, trademark, it becomes a prima facie. Is it necessary to apply for trademark registration? It is not. But if you do not apply for trademark registration, you may not get protection under the Trademarks Act. And if you want to exercise your rights, you have to go under the common law rights. And you have to apply for, you can apply for passing of action. So it's always better to file a trademark application, and the registration of itself will make as a prima facie evidence that you are the first and honest user of the trademark. So when you make an application, what are the section 9 speaks about the absolute grounds of refusal. The trademark which are devoid of any distinctive character. I mentioned about Tata Bye-Bye Motors and Tata Motors, devoid of distinctive character absolute grounds of refusal. Now, if my trademark is, I'm talking about the best painkiller. If I come up with this trademark, best painkiller or the fastest painkiller as a trademark, then it will not have any protection. If I talk about any kind, quality, quantity, intended purpose, values, geographical origin, if I say about, like, if I try to protect Kolhapuri chappal as my trademark, it will not be granted. For example, like since 1900, if I try to protect it as a time of production of the goods, that will also be not have any protection. The trademarks which consist exclusively mark or indication which have become customary in current language. For example, like for example, Marathi language, like "Khub chan" is like, means like very good, and if I try to protect it, it will also not have any protection, and it will be refused as a Section 9 absolute grounds of refusal. Further, if a trademark is such that it is a nature or deceive, if I want to deceive a public, if I want to put a trademark in such a way that people will be mistook that this is someone else's trademark and want to pass off my own goods, then again it will be refused. If there's a scandalous or obscene matter in my logo mark, then it will be refused. If I try to protect Narendra Modi, Mahatma Gandhi, Rahul Gandhi, then as a trademark, then it will not be granted under prevention of improper use of emblems or names. It will also be not registered if I try to put a shape of good as a trademark, it will be refused. Or if it is giving a technical result, it will also be refused. Now, there are relative ground of refusal. If there's an existing trademark which is identical, but and for the similar goods, or there's a similar trademark with the identical or similar goods, then it may be refused. It's a relative ground of refusal under Section 11. Or if there's an identical or similar earlier trademark, but not a similar goods, but that earlier trademark is a well-known trademark. For example, if I want to start a Reliance Education Institute, now Reliance School, or like rather coaching classes. Now Reliance as such, they don't have a coaching classes, but Reliance being so well-known, they're not in a coaching classes activity. So I will be refused under this particular section. Now, for example, if it is not registered, for example, there's a famous trademark, but it is not registered. So it can be also registered, refused just because under the passing of action. And again, if there's some famous copyright, under virtue of that copyright law also, a trademark application can be refused. So this is something very important. I wanted to bring this slide because most of you will have the pharmaceutical understanding. The section also speaks, like Section 13 speaks about the prohibition of registration of names of chemical element or international non-proprietary names. So whatever the name which has been commonly used, an accepted name of any single chemical element cannot have a trademark registration. Any single chemical compound as distinguished from a mixture in respect of a chemical substance or preparation, again, no. International non-proprietary name cannot be applied for trademark registration. Even if it is applied, cannot be registered. Assuming if they are registered, then there's another provisions under the same section that they're as good as in non-existence. So you will not be able to claim any monopoly rights over those international non-proprietary names or the chemical elements. So what rights do I get if I have trademark registration? Exclusive right to use a trademark, and also if someone trying to use my trademark and pass off his or her goods as mine, then I have a right to initiate infringement proceedings against that and get a relief against that particular person. Now, this is a flow chart of like how the trademark application will work. When a trademark is filed, you can file with the user or without user. You can say proposed to be used basis. Then it will undergo the examination. The examiner will issue the examination report. You have to respond to the examination report within a period of 1 month. If examiner is satisfied with your response, then he may allow the application to be advertised before acceptance. If it is not satisfied, then he may give you hearing to be heard, and then you can after the at the hearing you can explain that how your trademark is distinctive. And if it is advertised before acceptance, then it's open for the public to oppose the trademark application. If it is not opposed within a period of 4 months, then your trademark will proceed for the registration. Let's come to the copyright. One of the IP which is somewhat important, I mentioned about the packaging, but you are a faculty people and you may be sort of writing your research papers, and this is something you may be aware. Your research paper will also have protection, will have a protection under the literary work, and it can be copyrighted. If it is, of course, your research work can result, or if it does result into patented element, like if there's a novelty, inventive step, industrial applicability, then of course you can file a patent application. But the prima facie, your copyright, your research paper, the moment it is put in a paper in some tangible form, it will have a copyright registry or copyright protection. Then why to file copyright application? Again, it is not mandatory, but it becomes a prima facie evidence that you are the first person to come up with this research. And this is how you are protected. Coming to the packaging, now I want to show this example. This is on a just glimpse of it, it may look different, but when you're purchasing something, the layman may not always pay attention what kind of product is been given to him. The look and feel of it, it can be have a trademark infringement as well as a copyright infringement issue. So this is a simple process. If you see, there's an application, there's an examination, there's a response to the examination report. But in copyright, you have to give a no objection certificate from the person who have contributed to the copyright. Now, especially when it comes to software development. If I'm the owner of a software company, and then if I've employed 10 software developers and they have come up with a software, a particular software for which I want to file copyright application. So I have to file an NOC from all these 10 software developers. I can also attach my employment arrangement with my employees, in which I can mention that they were employed with me. But NOC is mandatory. Once NOC is provided along with the application, examination, if response satisfied, not satisfied, hearing, it's maybe granted. Copyright, so far in my personal experience, or the examiner may not usually issue the prima facie opinion that yes, this is a clear copyright infringement. But in my personal experience, I have not come across any copyright examination report so far. I mentioned about this slide. Yeah. Now let's come to the design. Design is for a feature of shape, configuration, pattern, ornament, or composition of lines or color. Either of these things has to be applied to an article, and that article, it can be, now there's no technical person in the field. It's judged solely by eye. So shape of Coca-Cola bottle is a design. If you see, the Bayer has filed the design protection for this particular tablet. In India, if I'm not making mistake, 5 pharmaceutical tablets have been published so far, and I think all of them have secured design protection. So, and with this, you can understand the patent is different from design. It's purely, let me go back to the previous slide. So it's purely speak about the feature, configuration, pattern, ornament, composition of lines, color. It does not discuss about how to reach that design or the way of or method of manufacturing that design. That will be protected under Patents Act, and under the definition of design, it has been captured. The method of manufacturing will not be protected under the Designs Act. It will have its protection under the Design Act only. Also, it also speaks about the trademark. If the design has certain particular trademark, it will find it will not be have a trademark raised protection, but only have a design protection. This is a flow chart that you file a design application. It will be numbered like a formality check pass. Again, there would be a examination of the application. Then if you remove the objections, for example, you respond to the examination report, then you're given an opportunity of being heard. In my experience, most of the examiners, they ask for the hearing. It's in Kolkata. It's a distance where you have to travel. Unlike you can file this design application in any of the office, but the hearing only happens in Kolkata. So if it is accepted, well and good. If it is refused, then you have an option of filing an appeal before the High Court, and then High Court may decide either accepting it or rejecting it, and this is how your design application will be protected. Now you have understood what are the IP, basic IP which you deal with in your research field or in a pharmaceutical industry, and as a academics as well. Now, when you're doing a research, what you should be looking at, there has to be a checklist like which you should follow. You have to check whether your university has any IP policy or not. Find out what does it speaks. Make sure whatever research you're doing, you're maintaining your detailed notes of your work. You submit an invention disclosure form known as IDF. You may be aware of it. And whatever you have, you feel you have discovered or created something unique, immediately put it on an IDF and share with the technology officer of your university. Mention, it is very important, mention all contributed to an invention or creation in your invention disclosure form. This is one of the ground. If you fail to mention the person as an inventor, then he can file patent opposition to your patent application, pre or post grant opposition, and he or she can have his name added to the patent application. Now, most important thing, don't publish your research before it is protected. This is most of the people. I think this mentality has been changed. People are becoming very conscious about their rights. But please, I want to reiterate it. Don't publish your research before it is protected. Check if you are using material or IP from others in your research. Now, for example, you may not be aware, but if it has already been used by someone else or protected under particular IP, you have to ensure that whether it's not infringing on someone else's IP. And since it's a research, you may not be infringing it, but a due credit has to be given in your research about that particular IP or about that particular person. Research patent literature. Now, this is something, a very tedious job. It's time consuming, and there's a plethora of information available. Thousands of patent file daily getting published all across the world, and most of them may be in your field of area also. It becomes very difficult. So there are sophisticated services also available in which you can funnel and identify the key patents or patent literature which is related to your technical invention. And then most important thing, patent or any IP research, it leads to it cost. There's always cost attached to it, and the way after once you get the patent, it may not give you money immediately. So you have to come up with the revenue generation model, and this is so you have to come up with a revenue generation model, and and once you have a revenue generation model, you will also have a visibility, and you yourself will feel encouraged of filing a IP protection. Now, technology officer I assume most of the university have the technology officer, and their basic job, like once you approach a technology officer, they will evaluate your invention, whether it's commercially viable or not. Now, this evaluation is very subjective because your patent is valid for the period of 20 years. And then it is very difficult to forecast that whether it will have any value after 5 years, 10 years, 15 years, or 20 years. So, but certain people are able to come up with the commercial potential, and the technology officer will help you in licensing your invention and setting up the spin-off. Now, I have worked with most of the universities, and sometimes like those into PhDs. In one of my experience, the PhD researchers, they had approached us directly, and they wanted to share their invention with us. And when I did the due diligence, I realized that that particular research was they doing it under their PhD also, and the IP policy was such that whatever research they do, the university will also have equal share in that particular research. So the invention was really fabulous, but since we did this due diligence, so we were not at risk. We not only entered an agreement with the researcher, but also with the university, and then we had everything clear. So also, I'll come back, you go back, find out what is the IP policy of your university, and work on it, and do research as much as possible, and try to create and invent a lot of things, whatever you can come across. With this, I would like to conclude my presentation. Now I can take questions. Perfect. Vansh? Hello?
In case participants have any queries or questions, they can put it in the chat box.
Thanks, Dr. Sheetal, for responding. I thought my entire presentation and I was on mute. So,
Dr. Sheetal is not here. I'm Riya Gupta from IPTSE.
Hi, Riya. Sorry.
Hi, how are you?
I'm good. Thank you. I hope I was audible and you were able to see my presentation.
Of course, sir.
Yes, thank you.
Okay, we have one question from the live chat box on YouTube. Hello?
Yeah. Yes, please.
So the question is, if the patent is of anti-cancer activity or mosquito repellent activity, can the compounds mentioned in the patent be used in study for other activities?
Absolutely. As long as, like, if you're having this, anything, if you want to study for other activity, you have used the word study. So there's a clear cut under the Copyright Act, there's a clear cut sort of like this will not be considered as an infringement. As long as it is studies, so you have a anti-cancer, mosquito repellent, combine it, study it, and then you may be able to protect it also, because these are two different, as long as you are able to showcase that it is not mere arrangement or mere admixture, you will get patent as well. But so far studies concerned, you're good to go.
One more question. What is the value of the Indian patent internationally?
Now, patent valuation is, I think there's one question also. So valuation of patent is very subjective, and there's nothing called a value of Indian patent internationally. As I mentioned, Indian patent is a law of India. It will not have any value internationally. It will have value only within the India. Again, the value of patent is determined with the various factors, that whether is there the field, whether it's a crowded field or it's very scattered field. There are not too many competitors involved. If there are very few players, then the value of your patent will go high. If there are too many players, the chance of infringement is high, then the value of your patent will go down. But just to answer, coming back to the main question, value of Indian patent internationally, nil. I think there was one more question. Why Indian patent and US patent law differ in era of globalization? Very interesting question. Now we are, I think it was asked by Vikas. Sir, Vikas, sir, very interesting question, that we are in the world of globalization. Sir, we also want to maintain our sovereignty. Now we are a developing country and we want to have certain rights with us, so far patenting is concerned. In this pandemic times, we want to go for a compulsory licensing of patents. And that's why there is a difference of, different patent law. If you see, in nutshell, the basic standard is maintained in all the laws, all the global laws, all the members of WTO countries. So this is how you'll understand. Minimum you have to adhere to, whatever above, go ahead. I think this, can we patent formulation of polyherbal drug from indigenous herbal medicine? Indigenous herbal medicines, of course you can. Just try and understand this. What are the criteria of patent? Novelty, inventive step, industrial applicability, right? And there's certain things, what are not inventions. The list of items are there, which are talking about what are not inventions. All you have to do is that able to identify whether your polyherbal drug has certain efficacy. It's not your mixture or admixture. And then if you're able to showcase all these three requirements, novelty, inventive step, industrial applicability, good to go. But if you're able to, in case your polyherbal drugs from indigenous herbal medicine, if it is obvious, or if it is falling under traditional knowledge, then I'm sorry, you may not be able to, obtain a patent for this formulation. I think there's one more question. How much time does Indian patent take till completion? Now it is a very interesting thing. If I was asked this question maybe 1 or 2 years ago, I would say years, 5 to 6 years, maybe 8 years, sometimes 10 years. But with the introduction of expedited examination, I have witnessed the patent has been granted in India within a span of 8 months' time. Things are improving, things are changing, which is a really good thing. I think there's one more question. How can domain name be protected? Superb. I really appreciate those whoever, Sunil sir. Sir, domain name, you should file for trademark registration. Reason being, if I have a trademark, say I have a domain name, www.sunilshah.com, and then I don't have a trademark registration, but it is your trademark. Sunil Shah is your name. It should be your trademark, and I want to take benefit from your trademark. If I do not have trademark registration for Sunil Shah, and you have trademark registration for Sunil Shah, then you can go before ICANN. ICANN is a body under the WIPO. You can go there, you can show your trademark registration certificate and say, hey, I'm the valid user, register holder of this trademark Sunil Shah, and Mr. Vaibhav Dalvi, he's a fraud and he wants to take benefit from my name, Sunil Shah, and hence his domain name should be removed, and ICANN will accept your trademark registration and you will be able to protect your domain. So reason I told this story, if I want to have your own domain name, file for trademark registration of that domain as well as the domain name, entire www, it could be .com, .org, .in, whatever it could be, apply for trademark registration. So I think, sir, why there's a country-wise segregation for patenting? Like if you had applied for US patent, only in US you can protect your work. How to protect work international? Okay, so there's something called, Patent Law Treaty, PLT, for which we are not participant. We have not accepted it. Patent is a monopoly right, and people think that it is not in favor of a nation when the basic medical needs have not been met. It's subject to a different interpretation or different discussion altogether. Can be renewed. But Mr. Soni, I'll just respond to your question. So if there's certain, for example, assume there's a, in USA, assume a patent has been granted in USA for turmeric. And if it is automatically applied to India, so whatever we have been used in India so far for turmeric may not be, we will not be able to use it without paying royalty to that US patent holder in India. And that's why each and every country are taking conscious efforts in order to meet uniformity, but also to protect our own people's right. Coming to Mr. Soni's question, yes, sir, patent can be renewed up to a period of 20 years. In India, patent is renewed, applied for renewal once it is granted. In USA, it's like in India, it's every year you have to pay, sorry, every quarter, same like USA, and Europe, you have to pay annually. In pharmaceutical industry, product or produce patent is important. Product patent, be it any industry, product patent is always important. People will always look for it because then you will be able to capture the market with that product. If you have a process patent, then there would be different products available with the different processes. Oh, sorry, identical product, but with a different processes. Still, there is a competition. There would be a competition for your own product in the market because you have a process patent. Right. Is there world patent has liable for royalty? Yes, certainly. So if I license my patent to you, I have a vaccine, but I do not have enough manufacturing facility. My manufacturing facility has been completely exhausted. I can approach someone, or someone can approach me, ask for a patent, technical know-how, and if I share that patent and technical know-how, then I can receive a royalty in India as well. And there is nothing called world patent. Right. I think we've been able to answer the questions. Steffi, over to you.
Thank you, sir. It was a pleasure listening to you. So, coming to the end of this session, I would like to request co-convener Mr. Vikas Kumar Jain, sir, Associate Professor IPER, to provide certificate of appreciation and deliver vote of thanks.
Thank you, Steffi, madam. This is my immense pleasure to present certificate of appreciation to Mr. Vaibhav Salvi, sir, the Day 2 eminent speaker and Day 2 International FDP on IPR and patent, sponsored by IPTSE Academy, New Delhi. Sir, you have enlightened us with your immense knowledge in various aspects of patent, IPR, like the patent, copyright, industrial design. So, sir, thank you very much for this knowledge, and sir, kindly accept it certificate of appreciation on behalf of IPER family. Thank you, sir. It's a very informative and wonderful session.
Thank you very much. Thanks a lot. Appreciate it. Steffi, you're on mute.
Thank you. Thank you, sir, once again.
Thank you. I think I'll take everybody's leave.
Thank you so much.
Thank you.
Thank you, sir, for the wonderful session.
Thank you.
Dear participants, we have few announcements for you. I request Akansha ma'am to share the feedback link of Day 1 and Day 2 again in the chat box. The participants who have joined through YouTube can find the feedback link in the live chat box of the YouTube. All the participants are requested to fill the feedback form if they have missed it. Attendance would be marked by feedback. The link would be active for next 30 seconds. Now, I request all the participants to kindly switch on their cameras for the photo snapshots. I request Vansh and Ria to kindly take the snapshots. Dear participants, we would be sharing the snapshots in the WhatsApp group.
Steffi, you want me to stay or I can exit?
Sir, please stay for snapshot.
Sure.
Dear participant, I once again kindly request you to switch on your cameras. Vansh and Ria, can you confirm if snapshots had been taken?
Ma'am,
Yes, I'm
audience is
actually
still
taking
switching
the
on the
screenshots,
videos.
but everybody's staggered. 1 second. I would request all of you to switch on your videos, please.
Thank you, everyone. We have taken the snapshot.
Snapshots are done. We'll share the same with you all.
Thank you all. With this, we come to end of day 2 of International FDP. I take this opportunity to thank all the dignitaries, speakers, and participants for sparing your valuable time, and I hope today's sessions were beneficial for you all. Thank you once again. We will be back tomorrow with session by Dr. Praful Gupta, Chief Scientific Officer, Organic Scientific. Thank you. Thank you once again.
Thank you.